So it is my great pleasure now to go to our number 2 agenda item, which is Janus, and to welcome Sale University Associate Dean Charlotte Garden, who actually was referred to at a appellate spring conference of the appellate judges as a Janus expert by one of her colleagues. And of course, I immediately, and others present, other justices were like, Janus expert? Oh my gosh. And so I had noted it myself, but received emails from others saying, Mary, Janus expert, structure work group. And so we're very appreciative that Associate Dean Garden was both able to make time in her schedule today, but also did a little more work that we asked if she'd be able to do for us. So we look very much forward to your presentation. We actually have a big chunk of time for you, thinking you might want to use it, and also knowing it might prompt questions, both from the members first, and once the members' questions are satisfied, if there's additional time, then I would allow questions either from those physically present or virtually present. So with that, I want to thank you again and welcome you.
Great. Thank you so much for that welcome, and I will attempt to live up to my colleagues' billing.
And may I interrupt for just 1 second to let you know that Andrea Jarman is on the phone. So she is present and with us and undoubtedly taking notes on her computer. So with that, we will begin. So all members are present physically or by phone. Again, I'm sorry, and please continue.
Perfect. Thank you so much. So I thought it might be useful for me to slightly expand the scope of what I was asked to talk about, which really focused on Janus and North Carolina Board of Dental Examiners and subsequent cases about the structure of different bar associations, to talk about some additional cases arising mostly in the union context concerning both what is chargeable to, in that case, represented workers, and also what procedures are required to protect the chargeable, non-chargeable distinction. So I'm going to do that with culminating with Janus v. AFSCME, and then talk just briefly about the 2015 case, North Carolina Board of Dental Examiners, with the substantial caveat that I am not an antitrust expert. And then I'll talk about new and pending bar association cases, many of which Dory hopefully grouped together for me, and then happy to take questions if that would be helpful. Okay. So we begin with kind of ancient history, a trio of cases arising under the Railway Labor Act. The first case on the list, Railway Employees Department v. Hansen, was a constitutional case. Street and Allen were both statutory cases, although Street was decided under the principle of constitutional avoidance, and so has this sort of constitutional valence, which ends up being relevant later. But these are the cases these are the cases in which the court creates the idea of a distinction between chargeable and non-chargeable activities when it comes to requiring people to pay money for the activities of private organizations. So in Hansen, the court says, the court holds that it's not unconstitutional on its face for a collective bargaining agreement governed by the Railway Labor Act to require represented workers to become members of a union, but leaves for future cases whether an employee might be able to bring an as-applied challenge if certain of the union's expenses amounted to compelling speech on the part of the worker. So that should all sound fairly familiar. That's the fundamental distinction that guides the remainder of the union cases and then also the bar association cases, Lathrop and Keller. In Street, the court makes good on the promise, if you will, makes good on what it sort of gestured toward in Hansen by saying that under the Railway Labor Act, unions can charge workers for the costs of their representational activities, but not their other activities. So roughly a distinction between bargaining and grievance representation and everything else the union does. And that includes participation in electoral politics, but it also includes things like new organizing. In Allen, the court begins to figure out what unions have to do in order to protect that distinction. What rights do workers have in order to ensure that their money isn't spent for unlawful purposes without their permission? And The court implies in Allen that unions ought to allow represented workers to opt out in advance rather than paying for potentially non-germane or non-chargeable expenses and then seeking a refund. The court also says that the calculation of chargeable versus non-chargeable expenses should be based on the previous year's spending. So the union totals up what it does, says, last year, 85% of what we did was related to our representation of workers. Therefore, next year, the mandatory fee, the amount of the mandatory fee or the agency fee will be 85% of dues. Okay. On the same day it decides Street, the court decides Lathrop v. Donahue. Donahue doesn't track Street, but it does track Hansen. So if you will, one way to think about this is that the Bar Association cases right now are one step behind the union cases. Donahue involved a lawyer who objected to paying $15 in bar dues under the First Amendment. Following Hansen, or guided by Hansen, the court issues a fractured set of opinions, but the plurality, authored by Justice Brennan, says that bar associations can charge for educational and ethics-related programs, and leaves for another day whether they can also charge for other activities, including lobbying. Other justices who join in, who concur in the result, say that there's no problem with bar associations charging for any of their activities. Okay. Next comes ABoud v. Detroit Board of Education, which is when the court holds for the first time in the union context that the First Amendment is triggered by compelled subsidization of speech in the form of requiring public sector union represented workers to pay dues or fees to the union that represents them. The court follows the Railway Labor Act approach. It's interesting because the court is adopting really for the first time squarely the First Amendment principle against compelled subsidization of speech, and yet the court doesn't give as much explanation as you might imagine. Instead, it says, we decided this in these Railway Labor Act cases. In the union context, the court is balancing and agrees that employers, public sector employers and unions can balance a set of considerations that are present in the union context, but perhaps present in a different way or differently present in the bar association context. In the union context, unions are required to comply with something called the duty of fair representation. They have to treat represented workers fairly, whether or not they belong to the union. The DFR standard is sort of similar to the business judgment rule. And a union that is elected to represent a group of workers represents all the workers in a bargaining unit. So one reason for requiring represented workers to pay an agency fee is that if you say the union must represent everyone in the bargaining unit and it must do so fairly, whether or not they join the union and whether or not they pay dues, that will create an obvious free-riding incentive. So the court says, look, we think that the First Amendment is implicated by requiring people to pay money towards the cost of union representation, but applying a sort of generalized balancing approach, the court says the combination of the duty of fair representation and exclusive representation justifies a rule that requires people to pay an agency fee. Of course, that's, up to states can modify that rule, but up until Janus, about half of states allowed some workers to require some workers to pay an agency fee. Only later comes a set of procedural protections to enforce that line. Okay, so let me I know Chief Justice Fairhurst said wait until the end for questions, but I wanted to just check right now to see whether there were any questions so far. Okay.
So I'm going to interrupt quickly. I just need to remind everyone on the phone, if you are listening in, please mute your line when you're not speaking. Again, if you're on the phone, please mute when you're not speaking. Thank you.
Okay. After ABoud, there are some important developments in the law of procedures to protect union dissenters or union objectors. The most important of these cases is Chicago Teachers Union v. Hudson, a 1986 case. In that case, the court flatly and squarely rejects the pure rebate approach. Employees have to be able to opt out of non-mandatory fees in advance rather than having money charged and being reimbursed after the fact. Unions also have to supply people information about how they calculate the agency fee, and allow them a process, such as an arbitral process, to challenge the calculation. Okay. And in addition, during that arbitral process, the unions are required to escrow the disputed amount. The list of chargeable and non-chargeable expenses then gets refined in a case called Lathrop v. Fairhurst Faculty Association. The only thing I want to say about Lathrop, because I imagine you don't care tremendously what is germane and not germane in the union context, but Lathrop highlights that there are two approaches to figuring out when an expense is germane and when it isn't. The approach that the court adopts looks to what expenses relate to the legitimate state interests that the state and the union adopt in litigation when they're justifying their agency fee. But Justice Scalia, concurring, suggested that what is chargeable ought to instead hinge on what functions are statutorily required of the union. So that would be a somewhat narrower set of chargeable expenses, right, linked to what legislators do, rather than a somewhat broader set of expenses linked to how the state kind of more generally thinks about why it has public sector collective bargaining. Okay. Now we're back to the Bar Association context. In the 1990 case, Keller v. State Bar of California, where the court says that bar associations are similar to unions. So the State Bar of California said the rule against compelled subsidization of speech by private entities doesn't apply to us at all. We, the Bar Association, are a public entity. The court rejected that. The court said bar associations, or this bar association, I should say, seems more like a union than a genuine arm of government because its funding comes from dues rather than appropriations, because its activities are essentially advisory, right? Because in this case, final word on disciplinary or admissions decisions rested with the Supreme Court, and because the Bar Association was charged with representing its members rather than representing the public. So the court, tracking the reasoning in the union cases, said that chargeable activities were those that were necessary or reasonably incurred for the purpose of regulating the legal profession or improving the quality of legal services. That's linked to what the state bar articulated in terms of its legitimate governmental interest to require payment at all. The court doesn't say that it's applying something like strict or exacting scrutiny. It generally refers to First Amendment scrutiny. And that becomes important later when the court in the union context says, in ABoud, we were applying some kind of squishy balancing test, right? But we're instead, in later cases, saying exacting scrutiny applies to compelled subsidization of speech cases. The Keller court left for a future day whether bar associations are required to adopt Hudson procedures, or whether alternative procedures might also meet constitutional muster. So the court says Hudson procedures would be enough. We're not deciding whether something else would also be enough. Finally, the court doesn't address a claim that bar associations shouldn't be able to use the name bar association to engage in non-germane activities, but that was a claim that existed, an argument that existed in that case. Post-Keller, circuit courts have taken different positions on whether the pure rebate approach is permissible in the bar association context. The First Circuit rejected that approach. The 11th Circuit allowed it. Some debate about that. Okay. So in 2012, a case that began as a legal backwater, if you will, sent ripples through the labor law community because the court held in a case about whether Knox was about whether a union had to issue an additional Hudson notice and allow an additional opportunity to opt out of non-germane expenses when a union charged a mid-year dues increase. So that's not something that happens very often, as you can probably tell from the fact that it took until 2012 to reach the Supreme Court. But the court did two things. First, the court held that exacting scrutiny applies to compelled subsidization of speech, and signaled that it said that ABoud was an anomaly and all but sort of invited more cases raising compelled subsidization of speech issues. And additionally, it imposed a rule that nobody in the case had asked for and nobody had briefed, that unions must obtain affirmative consent before charging non-members any portion of a mid-year dues increase. Two parts of that are relevant. One, the court said in a mid-year dues increase, by definition, something unusual is going on, and therefore unions shouldn't be able to rely on last year's calculation, right? Almost by definition, the court says last year's calculation isn't going to be helpful, right? If it were, then the union would have set its bar dues at the right amount at the beginning of the year. And furthermore, the risk of overpaying shouldn't have to be borne by the objector, right? The court says essentially that the objector has First Amendment rights here, the union doesn't. Therefore, where we have to allocate a risk, the risk runs with the union. Second, the court said that a default, whether or not you opt out of paying non-mandatory fees or whether you opt into paying non-mandatory fees, is salient for purposes of the First Amendment, right? And again, for the sort of who bears the risk reason, said that in this context of the mid-year dues increase, right, an opt-in default was required. Okay. Next comes a 2014 case called Harris v. Quinn, which I don't have a slide for. Harris v. Quinn had to do with home health care aides who were hired individually by customers in states including Washington, but paid by the government through Medicaid block grants. The Supreme Court held that ABoud didn't apply squarely to them, and the court declined to extend ABoud to cover them. But what's interesting for our purposes is that the court talked about or rebutted, dismissed, if you will, arguments that Harris could have some impact on bar associations. So there had been a brief in the case from past presidents of the D.C. bar. The union and state parties had argued that striking down ABoud, which is what one of the things the petitioners had asked for, would affect the administration of bar associations. The court said, respondents contend that this case will call into question our decisions in Keller. Respondents are mistaken. The court continued that states also have a strong interest in allocating to the members of the bar rather than the general public the expense of ensuring that attorneys adhere to ethical practices. Thus, our decision in this case is wholly consistent with our holding in Keller. It's a little bit difficult to know how much to make of that. In one sense, it seems like the court is reassuring bar associations. Don't worry, right? The cases about unions have at least potentially diverged from the cases about bar associations. But another way to read it is that Harris was about whether ABoud should be extended, ultimately, right? That's ultimately how the court characterized its holding. And extending ABoud isn't necessarily relevant to the bar association cases. So when 4 years later, the court reverses ABoud, right, unclear whether it's reasonable to continue to rely on this statement about the ongoing correctness and validity of Keller. Okay, in 2016, the Supreme Court affirmed ABoud by equally divided court. That was after Justice Scalia died. And then in 2018, the court decided Janus v. AFSCME. So the court applied exacting scrutiny, just as it said it would do in Knox and Harris. It said applying exacting scrutiny, union agency fees can't be justified by state interests in labor peace or in preventing free riding. So that means that public sector unions can't charge for any of their activities or can't issue mandatory charges for any of their activities. The court relied on the existence of right-to-work laws in the public and the private sector. Where a right-to-work law is in place, it means that workers can't be required to contribute towards the cost of union representation. So the court says, well, those unions seem to be able to function just fine. That suggests that labor peace or avoiding free riding can't justify the impingement on First Amendment rights that comes with compelled subsidization of what we used to think of as union germane activities. The court emphasizes that all union speech is inherently ideological. The court says bargaining is ideological because union bargaining demands, if accepted, could mean more public spending, right, a bigger public budget, and that people could have political objections to that. And then second, the court extends Knox. Unions have to obtain affirmative consent, right? The court adopts a clear and compelling evidence standard before paying for any non-mandatory fee, which is now any fee. The court majority does not cite Keller, so less than helpful for our purposes. Okay, let me pause again there because I'm about to switch to North Carolina Board of Dental Examiners. Okay, great, okay. So I'm a little bit out of my wheelhouse here, but North Carolina Board of Dental Examiners, the 2015 case, the Board of Dental Examiners is comprised mostly of practicing dentists. The dental board decides to exclude non-dentists from providing teeth whitening services after dentists complain that they are being undercut by these non-dentists in the marketplace. The board sends a series of cease and desist letters, 40-some cease and desist letters, telling people that they were engaged in the unauthorized practice of dentistry, which is a crime in North Carolina, as I imagine it is everywhere. The dental board isn't overseen by any North Carolina state official. So the issue is whether the Board of Dental Examiners qualifies for state action immunity or what's called Parker immunity from antitrust law, which applies only to non-state actors if they are acting pursuant to a clearly articulated anti-competitive policy, and that means clearly articulated by the state, and if the state is actively supervising the implementation of that policy by the non-governmental group. The court said, well, the board is designated a state agency, but it still has to be supervised by the state. So just designating the Board of Dental Examiners as a state agency isn't enough when the putative state agency is actually comprised of a group of active market participants who get to impose barriers to entry. And the reason for that, right, is just the obvious risks of self-dealing, right? And the facts here couldn't have been more clear that that was what was going on. The court, of course, doesn't eliminate state action immunity. It just says that the state supervision requirement applies to these nominally public agencies that are controlled by market participants. The requirements for what qualifies as active supervision are flexible and circumstance-driven, but at minimum, the supervisor has to review the substance of anti-competitive decisions, has to be able to modify and veto those decisions, and may themselves not be an active market participant. And the court cites with approval two cases concerning bar associations, Goldfarb v. Virginia State Bar and Bates v. State Bar of Arizona, both of which involved the application of Parker immunity to state bar associations. In Goldfarb v. Virginia State Bar, the court struck down a bar association arrangement where the bar was run by lawyers who imposed a fee-for-service schedule, right, a price-fixing scheme, if you will, not at the direction of the state Supreme Court or the direction of the legislature. So that wasn't adequate supervision. In Bates v. State Bar of Arizona, the court granted state action immunity where rules were directed by and subject to approval by a policymaker. And a policymaker could be either a legislature or a state Supreme Court. Okay. That brings me to post-Janus developments having to do with bar associations. There's a case called Fleck v. Wetch, which came out of the 8th Circuit in 2017. That decision has been granted, vacated, and remanded by the Supreme Court, which I don't read particularly anything into. But Fleck involved North Dakota's procedures for implementing the Keller germane non-germane divide. So the plaintiff in Fleck argued that the North Dakota Bar Association hadn't done enough to comply with Knox's and now Janus's opt-in requirement. The court, however, the Eighth Circuit held that when the Bar Association sent around a notice that said, here's the amount you should pay if you want to pay full freight, here's the amount you should pay if you want to pay just the germane portion of bar dues, send a check to the corresponding amount, was really not susceptible to analysis of an opt-in or opt-out analysis at all, right? I mean, the Bar Association was giving lawyers the information they needed to make an affirmative choice about whether they wanted to pay full freight or not. The Eighth Circuit said, like, that's clearly good enough, right? That meets Knox's requirements, and that seems like it has to be right to me. Okay, and then there are a set of post-Janus complaints that make a series of arguments, the most far-reaching of which is that it is unconstitutional to require people to pay any money to an integrated bar association. So that would be a direct application of the first holding in Janus if the court accepts those arguments. So in Shell v. Williams, in Crow v. Oregon State Bar, in Gruber v. Oregon State Bar, there are similar sets of claims, right, asking the court to apply Janus to the Bar Association context, and they make kind of a series of arguments from the most far-reaching to less far-reaching. So these plaintiffs argue that requiring membership in an integrated bar association isn't necessary, it isn't justified because a state could regulate attorneys in a different manner, such as having the state Supreme Court do it without the assistance of a bar association. They argue states could adopt a non-integrated bar association model. Alternatively, these plaintiffs are asking for more robust procedures to prevent payment for non-germane expenses, such as more detailed accounting from bar associations about what they are counting as germane and non-germane speech, and also an affirmative opt-in for non-germane speech, especially where states don't have the North Dakota style, like you decide, right, on this form whether you want to pay full freight or not. I will say that a lot of these complaints focus heavily on what is published in bar association magazines, and in the Oregon case, in which a magistrate judge has recommended dismissing the complaints, there's a great deal of discussion of what is in the Oregon Bar Journal. I will say that in the union context, it's been the rule for decades, or it had been the rule for decades pre-Janus, that unions could count as chargeable expenses that went to writing up chargeable activities in union newsletters, right? So if the underlying activity is chargeable, then you can charge people for writing about it in a union newsletter and vice versa. And so union staffers literally go through and count lines, right, to calculate what is chargeable and what isn't, because there are lots of cases, right, in challenging calculations in the union context. It seems like the Oregon Bar argued, as I understand it, that it's ex ante limited its bar journal to writing about things that were germane, and it reads germane fairly broadly. So to the extent a court is interested in cutting back on what counts as germane and what doesn't, that might be one area where that happens. Okay. I think that is more or less what I have to say. I mean, I guess in terms of sort of takeaways, I think it's worth considering whether there are any differences in the Washington State Bar structure that would justify an argument that the State Bar is a state agency for First Amendment purposes, which would take these arguments off the table. I have no idea if there is or not, right? Obviously, the California Bar Association unsuccessfully attempted that argument in Keller. Assuming the bar isn't a state agency, right, the court will likely apply exacting scrutiny to a potential case. I have no idea how likely such a thing is. If that happens, then I think the Hudson-Knox-Janus procedures would be safer than alternate procedures, even though the court in Keller didn't mandate Hudson. And then also it's worth sort of thinking about chargeable versus non-chargeable subjects. It's possible a court would cut narrowly, sort of equating in a way that makes it more difficult to count things that look ideological as germane or chargeable. There are some alternatives that I know unions have been thinking about in terms of alternatives to mandatory fees, appropriation from a general fund, becoming a true government agency. I don't think any unions are actually thinking about that, but some people have been talking about it. Internal organizing and orientation. So a bunch of unions have taken steps to ensure that they can do an affirmative orientation for new hires to say, here's who we are and what we do and why it would be a good idea for you to voluntarily become a member. And fee-for-service or membership incentive models. So, if you become a member, you get, in some union examples, some valuable insurance benefits or other benefits that, that people want that are the kind of extra nudge, right, to pay even though you don't have to. And with that, I would love to hear any questions that you have.
So I may have missed, but last week I think it was, there was a district court decision in the Gruber case. Do you want to touch on that? I mean, my reading of that was that the court said that that they didn't think Janus overruled Keller, and they also said that the plaintiffs in this case had not really exercised all their opportunities under the Keller decision to have their grievances corrected.
So is this the magistrate recommendation of dismissal?
Yes.
Yeah. Yes. So, I think it is reasonable to say that Janus on its face doesn't overrule Keller, right? And I think the question is just whether that's the next case or not. I do think that there are different justifications for mandatory bar fees than for union fees, and that there are many good arguments in support of Keller's fundamental distinction, even if a court ultimately decides to engage in more supervision of what's chargeable and what's not, right? Which is the path that the court took in the union context. So, sets up the structure, then refines it in a series of additional cases to decide what's chargeable and what's not.
Other questions? Questions from I'm sorry, Fred, and then Eileen. Fred.
My question might be multifaceted,
Sure.
But looking at this string of cases and our group, this structure work group, to make sure that the system we have is constitutional, I took a couple points out of what you said, which one was that we need to ensure that there are robust procedures in place to protect members from having to pay for political speech. I mean, that needs to be an ongoing battle that we deal with. Is that correct?
Well, let me say this. In the union context, that has been true. I would say that in the union context, there have been many more cases and much more policing for various reasons, including that, it's relatively easy for union objectors to find lawyers to take these cases. And those cases have, I think, required unions to engage in the robust and ongoing.
So if we didn't follow the Harris line saying that they're different, I mean, if it was
Right.
pushing, we would be safe to have robust procedures. That's something that even if the Janus decision was extended, that's a piece that would help us maintain our system.
I think that's right. Assuming the court isn't going to say, every part of Janus applies to bar associations,
Right.
which I think is unlikely.
Okay. The next part, you're talking about the the policymaker needs to be, I guess, elected either the Supreme Court or the legislature. So here we have the Supreme Court. So in also structuring this to avoid the largest number of challenges and objections, one of the things is to make sure that the Supreme Court is the policymaker.
Yeah, that strikes me as the... Yeah, so I think in North Carolina Board of Dental Examiners, so that is my takeaway from North Carolina Board of Dental Examiners, and here I feel like I must reissue my caveat about not being an antitrust expert.
Well, and one of the ways to do that, it doesn't mean that the Supreme Court, Mary and her colleagues are very busy. I mean, micromanaging things may not, but one way to ultimately have control over WSBA actions is to have a veto power, wouldn't it?
Yeah, the veto power is one thing the court mentions in describing the qualifications for active supervision.
Okay. Yeah. So we don't have to put on Mary's shoulders all of the hiring decisions of the WSBA.
I think that's right.
But if the Supreme Court had the veto power, that would be one indicia of the policy control.
Yes, absolutely.
Okay, thank you.
Thank you. And actually, I had one other question because you turned your head, and so I didn't hear the last part of your sentence when you said that would depend on whether the court said all of Janus applied to bar associations, which you thought was
unlikely.
Unlikely.
Yes.
Okay, thank you. So the number of these cases talk about what isn't a state agency or what makes a bar association not a state agency. Is there anything, for example, I forget which was that it was a member services organization, whereas GR 12 here has as objectives, its first one is protection of the public. Is there any indication or sign of what makes something a public agency?
Well, I can tell you what the court relied on to come to the opposite conclusion, but not what would make the Supreme Court say, yes, this is a public agency. And so in Keller, it's a relatively short discussion, but it's dues versus appropriations, advisory versus policy-making authority. So that cuts in the opposite direction from North Carolina dental examiners. And then what you were just alluding to, representing the public versus representing lawyers.
Hunter.
Well, first of all, thank you very much for the presentation. That was extremely helpful. In talking about the case law, it strikes me that there's an additional development that's taken place over the course of the last year, and that's the addition of Justice Kavanaugh to the court. It might be somewhat of a limited exercise in that previously he served on the lower court, but are you aware of any cases that he has dealt with previously that present similar issues to what we're looking at in Janus and or any writings? I will tell you, I am unaware of any, but I'm wondering if you know.
Likewise, I am unaware of any. Yeah.
Thank you.
Anyone who's physically present have a question? Yes. Why don't you come to the microphone, Doug, so that everyone can hear you, please.
Doug Enday, I'm interested in your observation that you thought it was unlikely, ultimately, that the United States Supreme Court would apply the entirety of Janus to bar associations. And I'm interested in why you think that is. Is it because bar associations are less problematic from a First Amendment standpoint than unions, or for other reasons?
So it's two reasons. One is to the extent we can make something of what the court said about Keller in Harris. I think that implies that the court would be reluctant to say nobody can be required to pay any money to a bar association. Second, I think the court in Janus drew a distinction in the context of talking about whether public sector agency fees could be justified under the Supreme Court's public sector employee speech line of cases. That focused on the idea that when one employee goes into their supervisor's office and said, I'd like a raise or a promotion, that's an issue of private concern. Whereas when a union says we think everybody should get a raise or we think promotions should be structured in a certain way, that's inherently a matter of public concern. And it strikes me that the individual discipline or admissions decisions seem more like the former than the latter, and that a court might see it that way. I guess the last thing I'll say is, of course, the court is made up of lawyers who have, come up in a system of, discipline that has of admissions and discipline being controlled by bar associations, at least in most states. And it seems to me that the court may see that may lead the court to see bar associations as less problematic than public sector unions.
Right. I think the last observation is an interesting one. And I've also seen some analysis of which jurisdictions, which of the United States Supreme Court justices practiced in before being elevated to the bench, and it's a mixed bag. Some of them were in bar association states and some were not. Thank you.
That's a good observation too, Doug, in trying to read the tea leaves. Mm-hmm. Other questions? Anything from the phone, Dory? All right. Anything? Yes, please, Mark.
This is not, again, and maybe perfectly in your wheelhouse, but are you aware of any decisional authority where there is, because we're sort of, the Bar Association is sort of betwixt and between as far as public agencies. Mm-hmm. The Supreme Court has their constitutional authority to regulate us. The employees of the bar are PERS employees. Mm-hmm. They're in the PERS plan. Okay. So there's, we're not.
Mark, you'll have to speak up.
I'm sorry. It's not like apples and oranges, but it's like Jonathan's and Honey Crisps or whatever those, So are you aware of any decisional authority where there's an entity is held to be the equivalent of a public agency without being, for example, exactly like the Department of Social and Health Services or et cetera?
I have to say I'm just not sure. I'm sorry.
That's a fair answer.
It is sort of unique because the Bar Association has always sort of been described as sui generis, and with sort of which camp you're in depends on what works to your benefit or not. We are going to, Dory will talk about someone who we're hoping to hear from at the next meeting, if you would, the one that would be coming from Nebraska or talking to us from Nebraska, which might give us some insights into that question.
Okay. So since our last meeting, I had a conversation with a regulator from the state of Nebraska because in 2013, the Supreme Court for Nebraska issued an order that within 25 days between December 6th and the end of the year, they would go from being a mandatory bar to a voluntary bar right over the Christmas holidays. Get her done. So they knew that they had 23 statutory references in their code to various attorneys needing to be members of the association, which is to say that 25-day interval was probably not going to be sufficient for them to engage with their legislature to go throughout the code and modify all of those statutory provisions. So what the court did is they indicated that, okay, well, in order to align to all those statutes, we are going to make bar membership mandatory, but the only portion of your fees or dues that you're expected to pay are the $98 that are truly licensed regulatory fees. And everything else that needs to be funded by way of a bar activity is going to be a voluntary payment. And so I asked if, given that very hybrid, unique in all of the United States model that they have, if there's some good, bad, and ugly lessons learned that they could share. And she was able to relate some pretty significant insights. I'll just kind of speak to some of the highlights. This was a discussion I was having with an eye toward if what she had was insightful for this group, maybe we can arrange, thanks to Rex and his ability to technologically arrange this, have her join us remotely. She indicated that in their experience, they've grown to understand that maybe it's advisable, for example, to have your client protection fund be on the mandatory side as part of the directly related to regulation of the practice of law. Similarly, if your lawyer assistance, your attorney assistance program is not in that mandatory side, it's as part of the voluntary ones, attorneys who maybe need those services will be reluctant to engage with them because they feel as though they have not paid into them. And so that's something to maybe consider if you feel like that's profoundly helpful for the legal profession. She also spoke to structurally this notion of organized squarely within the public sector, meaning reporting as a public agency, that sort of thing, as opposed to some other structure, maybe corporate in nature. In their experience, where the regulatory side is very public in nature, such that it relies on appropriations from the legislature, anytime one of their sub-accounts related to license fees develops anything, something like a balance, the legislature sometimes eyes it for sweeping it. Whereas in jurisdictions where that's not the case, and they have it more as a corporate entity, those jurisdictions experience that when a balance accrues, they have a little bit more discretion to consider what sort of maybe access to justice programs relate so closely to the improvement of the legal profession that they can use some of those funds to maybe fund a project related to access to justice. So those were pretty important insights. And I asked further questions about if they understood anyone who, another jurisdiction perhaps, that was doing it differently in a way that could provide additional lessons learned. She explained, for example, that Kansas was maybe a good example of how to have organized even the regulation of practice of law side more corporately. Finally, it's pretty well understood that when your bar association is a mandatory bar association, there's an opportunity to be very public oriented in the activities because everyone has to pay in, and whether they like it or not, this is what's going to happen, and there's a benevolence opportunity to be truly in public service then. Whereas the perception exists that some bar associations that are voluntary have to be a little bit more commercial in their organization. They have to demonstrate value to the prospective members in order to entice them to pay voluntary dues. The actual lawyer practitioners, what have you, have to perceive that they're going to drive benefit. And so it changes kind of the focus in some occasions of the bar association. And this individual also shared with me that where that is the case, Iowa offers a model of a voluntary bar, but that nonetheless is still attracting a lot of membership in the interest of doing public good kind of projects. So it felt like those were helpful lessons learned to kind of inform some of our next discussions.
Eileen and then Paul.
Justice Fairhurst made reference to the fact that there have been cases in Washington challenging and discussing the State Bar Association, which was created by the legislature. Has there been in any of these cases a discussion of an appropriate deference to a state's determination of the appropriate way to regulate its legal profession?
In the Supreme Court cases, like in Keller?
In Keller or in any of the other cases that you've looked at?
You know, I think that almost in the fact that the State Bar Association cases haven't quite kept up with the union cases, I think one reason for that may be that the court sees a bar association's that a state's own regulation of its legal profession is an important interest that states have to be able to sort of pursue in the public interest. I mean, there's some discussion of that in Keller when the court talks about the legitimacy of the state's interest in improving the quality of legal services, of improving the legal profession. So I do expect that unlike in the union context, where in Janus the court said avoiding free riders, preserving labor peace are just not interests that work anymore, that in the Bar Association context, the court is, I think, likely to hold the track and say these are important interests for states to pursue. And if anything, focus on, is there a different way for states to pursue them?
Paul.
And actually, my question's more directed toward Dory. In the context of your discussion with the folks from Nebraska, and them saying that keeping the client protection funds on the mandatory side had worked well for them, do we know whether or not the Nebraska state constitution prohibits, as does the Washington Constitution, the gifting of public funds for any private purpose?
So to clarify, my perception from our conversation was that they had not chosen to keep the client protection fund on the mandatory side, but that they have come to feel as though that might be a valuable thing to have done. But with respect to how their state constitution looks as compared to ours, I don't have that information.
And just as a follow-up statement, I think it would be very informative to have more comparative analysis from states that have gone through bifurcation or that have mandatory, bars versus voluntary. I think California went through that process recently, and I would really, I think we'd all benefit from hearing exactly what happened across the board there, in particular with regard to their sections.
Agreed, and that's what we intend to have on the next agenda. Okay. Yes, Hunter.
This is just the genesis of an idea, but I'm wondering if you see anything that would be helpful for us to think about from the court's prior ruling or rulings addressing lawyer advertising. And I'm sorry, I don't have the case in front of me. It might have been something Illinois. I may be incorrect on that, but the Supreme Court's ruling saying that prohibitions on lawyer advertising was unconstitutional. And obviously that was a restraint on First Amendment speech, and here we're talking about compelled speech. But it seems to me that the argument in defense of prohibitions on lawyer advertising was essentially lawyers are special. The legal profession is special. Do you have any thoughts for us on that?
I do think that there, and like you, I'm like trying to remember the name of the cases, but yeah, I do think there are some First Amendment cases that say lawyers are special, and that might be that sort of line of thinking may be one reason the court may not say, we're going to take Janus and plunk it down in the Bar Association context. I do think the court has, so the court's decision in Nifla v. Becerra said we are likely to reject the idea that there's something called a category of professional speech that can be regulated more robustly than than regular speech. There are, ongoing cases about the extent of Zauderer, the case about whether attorneys can be required to give non-misleading, truthful information in their advertising. The court says yes, but there are, ongoing disputes about how broadly Zauderer can be applied, including Zauderer's requirement that speech be uncontroversial. In Nifla, the court read that to mean not uncontroversially true, but uncontroversial in the sense that somebody does or doesn't want to share the information. So I guess I would say yes to lawyers are special, right? Both as a general statement and in the Supreme Court's speech cases.
Well, and I'm sorry, I don't mean to interrupt, but just for clarification, didn't the court reject that analysis and saying that, no, actually, lawyers are great, you're wonderful, but you can't prohibit lawyer advertising?
Well, I think the court, I want to say, and I wish I had reread these cases before
This is my
coming
fault,
here.
I apologize.
I think the court allows some restrictions on lawyer advertising, right? I'm remembering there are a pair of cases, Orlick and Primus, where the court says that states can more narrowly restrict advertising by for-profit lawyers than by non-profit lawyers. So the court upholds restrictions in, I think Orlick was somebody who I believe was mailing solicitations to people who had been in accidents. And then Primus, I think, was an ACLU lawyer who was asking to represent people pro bono and said the solicitation, Bar Association can reasonably regulate the first but not the second form. solicitation. And I would see that as maybe one iteration of sort of lawyers are special. I don't think the court would ever say lawyers are special, right, in sort of black and white. But yeah, I do think it's fair to say that there have been cases where the court has arrived at First Amendment conclusions that, in the attorney context, comport with generally held expectations about how lawyers are regulated.
Thank you.
Sure.
And don't you think that's partially true just by the fact that we are the only self-regulating profession, and doctors and dentists and dog groomers and everyone else is under the Department of Licensing or some other sort of executive governmental agency?
Oh, that's interesting. Yeah.
I mean, arguably, just the fact that we're even having this discussion is indicative that, at least to date, there has been some deference to lawyers or the judicial branch being involved with lawyer licensing and regulation.
That makes sense to me. Yeah.
Okay. Other thoughts or questions from anyone? All right. Well, thank you very much.
Thank you.
We very much appreciate your time, Associate Dean Garden, and look forward to you following our efforts. And if you have other observations, thoughts, suggestions, we, of course, would welcome them. Thank you.